Everyone, this is Keith Carlson and Carlson and Jayakumar. Wanted to bring you a few of the cases we're looking at for the Ninth Circuit and the California Courts of Appeal in the middle of October. One is called EG versus ML, and this is actually a family law case out of Santa Cruz Superior Court. I wanted to let you know about it because it involves the court granting a restraining order against someone who had doxed or posted personal information about another person online. The accused said the restraining order would deny her First Amendment rights, freedom of speech, and the one who was doxxed said she was distressed and afraid because of what had been posted about her. The court ended up granting the restraining order out of concerns for EG's privacy and well-being. The Court of Appeal largely affirmed the order. And given the recent violence prevention laws based in the employment context passed in California last year, applying to employers this year, we note that there are some provisions that allow employers now to seek restraining orders on behalf of their employees, even if their employees aren't doing that. And thus, when a restraining order like this against online posting and doxing and that sort of thing is happening, it just calls to attention that the employer might have some obligations or opportunities for a restraining order that protects an employee, even in the online or social media realms. So keep that in mind and just keep an eye on where things are going in the doxing realm and the online harassment of employees, potentially. Another one from the line of cases involving COVID regulations and laws is called Montana Medical Association v. Knudsen. This is a COVID case. A lot of these are making their ways through the courts right now. This one, a Ninth Circuit review of a Montana state statute which prohibited employers from discriminating based on a person's vaccination status. The Medical Association of Montana challenged this on a theory that the state statute, the anti-discrimination based on vaccination statute, doesn't actually comport with federal rules as set by CMS. Specifically, CMS says healthcare facilities that receive federal funds must make sure their staffs are vaccinated against COVID. But the Montana Medical Association said Montana employers could not inquire about a person's vaccination status and yet had to comply with CMS rules, and thus there was a conflict. The Ninth Circuit said the Montana law was preempted by the federal regulations and thus put an order restraining its application, especially as the healthcare facilities, into effect. Next up, a little bit more on the litigation side for the attorneys out there is Katayama versus Continental Investment Group. Here, Katayama's team missed the 30-day response deadline to a request for admissions where they admitted or denied certain issues that the other side had propounded on them. The miss, according to the trial court, meant the party could not object to the request, and then the other party sought an order that all the requests were deemed admitted by the trial court. The trial court granted that motion, so all the RFAs were admitted, which substantially gutted Katayama's case. The Court of Appeal took a more lenient approach, reversed the resulting judgment that came from those broad admissions, and deemed the late answers with objections as having satisfied the substantial compliance requirement, and then by reversing that allows Katayama to try the case. Last one that we talked about in our prior video is under the line of cases coming out of the Ending Forced Arbitration in Sexual Assault and Sexual Harassment Act. Last time we talked about Doe v. Second Street Corp. This one is Liu versus Miniso Depot. Just like the Doe case, where there were acts that occurred both before and after the passage of the Ending Forced Arbitration Act, here too, some of the claims of the harassment occurred when the act had not been passed, and then some occurred after the act had been passed, and the court took the position that if any of the acts occur after passage of the act, then you cannot force arbitration. So those are just a few of the cases we looked at in this last week, and if you have any questions with any of those or others, make sure you reach out to us. We'll be happy to look into this further for you.